Thank you for being here. Good morning or good afternoon, depending on which part of the world you are. As a member of the International Insolvency Institute Board of Directors, and on behalf of all the board, please be welcome to this webinar. By the way, my name is Javier Lorente, and I am also co-chair of the III Latin American Committee. I know for sure that we all would like to have this panel in person or at least hybrid, but as many of you know, vaccine rollout in this part of the world is going pretty slow. So if you have any Pfizer, Moderna, Johnson & Johnson, or even a Sputnik laying around, please send me a chat and I will provide you my home address in order to get me vaccinated. Well, now seriously, and first of all, I would like to thank my Latin American Committee co-chair, Fabio Rosas, for allowing me to moderate this panel. I volunteer to be here today because I am profoundly envious of the several Latin American countries that were able to pass new insolvency laws amendment during 2020, precisely when, due to Corona crash, insolvency law is visible to general population. In my home country of Argentina, lawmakers proposed and attempted to pass at least 20 insolvency bills in the Congress, but not a single one passed. I attribute this failure, among other things, to political pettiness and infighting. While the Argentine government was failing its people, big surprise, countries like Colombia, Peru, and Brazil moved forward, and they effectively amended their insolvency regime, with Colombia doing it twice. While in some cases amendments are temporary, others are definitive. Today, we will hear from renowned specialists from the aforementioned countries about the amendments in Colombia and Brazil and the proposed bills in Chile and Mexico. Now I would like to make a brief introduction of all the four panelists. First of all, beauty before anything else, Diana Rivera Andrade from Colombia. She's partnered at law firm Rivera Andrade. She's a legal advisor and attorney on insolvency proceedings in Colombia. She's a professor in commercial law at Los Andes University, Javeriana University, and La Sabana University, member of the Ibero-American Institute of Insolvency Law, and founding member of the Colombian chapter of such institute. She's member of Insol International and of the International Insolvency Institute, and she's a regular assistant to Group 5 of UNCITRAL. Then Juan Luis Goldenberg from Chile. Juan has a PhD in law in University of Salamanca in Spain. He is an associate professor at the Catholic University of Chile. He is of counsel of the law firm Baraona y Compañía, and he is also member of the Ibero-American Institute of Insolvency Law. Then Francisco Satiro from Brazil. Francisco is professor of business law at Sao Paulo University Law School. He is specialized in insolvency law. He's a lawyer and founding partner of Satiro Law Firm. He's member of Insol International, the III, and the Turnaround Management Association. And last but not least, Luis Palomino Bernal from Mexico. He's managing partner of the firm Palomino, Flores, Hernandez, Abogados, with offices in Mexico City and Guadalajara. At the University Panamericana, where he got his law degree, he also obtained 6 specialties and 2 master's degrees. He is currently a PhD candidate in law for the same university. He is a member of the Ibero-American Institute of Insolvency Law and president of its Mexican chapter. He is also a member of Insol International, the American Bankruptcy Institute, and of the III, the International Insolvency Institute, our host today. Well, now it's time to get started with the real stuff. We have organized the panel with some questions to be answered by each panelist. And after those presentations, we will have some extra minutes for questions or reflections from the audience. The easiest way to propose them is through the chat in the Zoom app. My first question for all the panelists will be if you can briefly describe the core insolvency law amendments passed or proposed during 2020 in your country, and the order that we will follow, it will be first Colombia, then Chile, afterwards Brazil, and finally Mexico. Please, Diana, it's your show time.
Okay, thank you everyone. First, I want to thank to III and Javier Lorente for this invitation. And I hope that all the participants are healthy and will stay healthy. And I am so very happy to be here with my colleagues in this webinar. So for answer the first question, I want to tell you that the first documented case in Colombia was March 6th of 2020. After that, our government twice declared a state of emergency, like our constitution order. The first time was in April 17, and during that time, the government established 4 decrees related to insolvency. This law are in time is the duration is only 2 years until April 2022. So during before I explain what are the most important amendments to me, I want to tell you that before the pandemic, the Superintendency of Corporation, that is our natural insolvency judge, was working on a project to reform our principal in system that is contained in the law 1116. So some of these changes were already on the table and were activated because of the pandemic. So maybe that is a reason because Colombia answered so quickly to the pandemic crisis. The first amendment that I think that is important is the use of artificial intelligence. Even though we have been filing and looking at procedures online before the pandemic for the last 5 years at least, from September 2020, we can file 2 of the new restructuring proceedings, filing some forms with some documents attached, and the AI applies the rules and sets the admission, which is very, very fast, usually 1 day, in comparison with the normal time, 1 or 2 months. Before the pandemic, before all these new rules, the time to resolve a filing for a bankruptcy proceeding could be take 8 months, 9 months. That is so long for a company in a crisis. The second amendment is 2 new restructuring proceedings that are less judicial, more flexible, and with a major participation of the debtor and creditors, and with a judge with limited powers. So these are, the number 1 is NIAR, N-I-A-R. That is a proceeding of only 3 months. In this time, you have to reach an agreement about the passive and about the agreement with the creditors, and without insolvency administrator. So it's like auto-composition between the parties. And could be sectorial. What it means? What that means that you can file a proceeding with only banks or with only suppliers, and the creditors of these debtors doesn't receive any benefit or any detriment for this proceeding. So for these creditors that are outside, their debtor is not in insolvency. That is very good. The other one, number 2, is free. It's handled outside the court because we have a problem with the capacity of our court, and is in the Chamber of Commerce, and the Chambers appoints a insolvency mediator. The resolution between the different parties could be set or could be resolved for an arbitral tribunal. So these two new figures or cast of the members of the cast, like the mediator and the tribunal, are very new, and we have, for this time, we had one arbitral tribunal decided this kind of difference. It's also only 3 months and could be also sectorial. Third, the small proceedings or small insolvency for small companies. That is very important because we all know that a small company doesn't need a big proceeding. We need flexibility. We need that the proceeding is faster than the ordinary proceeding. So these decrees relate to micro and small companies which have assets of around $1.5 million. If you compare that with the SBRA, the law of the little companies in the United States, our size is very small because in SBRA is $7 million. We have here only $1 million. So these new proceedings are shorter in comparison with the normal procedure, and this will help to what? To reduce the duration and preserve the value of the asset that is at the end the goal of the liquidation proceedings. What happened the last year with these proceedings? The decrees are set in April, and from April to December, the numbers of the numbers of these proceedings, these small proceedings that are abbreviated reorganization and simplified liquidation, represent the reorganization 27% of all the proceedings, and the liquidation, simplified liquidation, the 7%. You have to think that the abbreviated reorganization normally was 18 months, 24 months. This proceeding is only 6 months. So the changes are very helpful. And the last one is two new rescue proceedings. Even we have rescue before these decrees, these 2 new proceedings are very realistic. Why? Because they are based on the value of the company as going concern and require a professional valuation. And that is a call for the people, for companies that are interested in some investing in Colombia, because all the system for rescue is go through the superintendency. So I think that is the 4 most important amendment for us. We are already working with these tools, and I think that maybe some of these will stay in the reform of our system. It's all this. Thank you, Javier.
Thank you, Diana. Juan Luis, what can you tell us about the very comprehensive proposed amendment that the president is trying to pass in the Chilean Congress?
Okay, thank you very much, Javier, also to the III. And as Diana was saying, best wishes to all regarding their health. And I'm very happy to be here with all these very fine conferences. Well, during the last year, during the course of the pandemics, there has been no news regarding amendments to our insolvency law. And I think that's it because we amended the whole system in 2014. So the system has been working very well, at least much better than the previous law. So there was a sense that there was no need for specific amendments in any sector. However, in order to continue with the proceedings, there has been issued some specific rules by both the Superintendency of Insolvency and by the courts. The Superintendency of Insolvency has issued some orders in order to continue with the renegotiation procedures for individuals that are held before the Superintendency of Insolvency is an administrative proceeding, and also certain rules for the actions of the liquidators and of the mediators regarding corporate insolvency. Also, it has been set a plan in order to sell the assets of the both the individuals and the corporate insolvency by means of digital platforms. And finally, the courts have accepted that the creditors' meetings and any audiences can be made via Zoom audiences. So that has meant that all the proceedings, all the insolvency proceedings have been followed like always without many problems. But the curfews and the lock-ins have also, of course, suspended some kind of actions during the proceedings. However, as Javier was telling us, there has been submitting a bill of law to the Congress by the government in order to discuss some major amendments to our insolvency regulation, but not based on the fact of the problem of the pandemics and its effects. It's much broader, and it's mainly based on some problems that have been observed during the last 6 years. Such amendment has been approved by the House of Representatives, and it's currently under discussion by the Senate. This Friday is the timeline for the senators to present some indications to the bill of law. So we'll see how things move forward. But at least up to today, the bill of law tries to cover some specific areas, mainly related to something that has happened also in Colombia. That's the new regulation or a modified regulation for small business. Our insolvency regulation since 2014 distinguishes the proceedings that are applicable to corporate insolvency and the procedures that are applicable to individuals. But within the corporate insolvency, there's no distinction whatsoever. That has meant that many small companies have not been able to use this proceeding, especially the reorganization ones. So the bill of law creates a new simplified reorganization proceeding for small companies, based mostly in the idea of the simplification of the proceeding itself. This means, for example, to ease the initiation of the proceeding by means of simplifying the documents that must be filed by the debtor in order to start a reorganization proceeding. It deals with the problem of the passivity of the creditors, mainly lowering the threshold, the majorities, in order to make the proceeding to advance. And finally, granting or enhancing the role of the mediator, that's called in Chile the veedor, in order to support the debtor or the small business in order to negotiate and submit a plan to these creditors. Other amendments deal mostly with the liquidation proceedings, also creating a simplified liquidation proceeding for both individuals and small companies. And here the focus has been placed on the discharge rules, because since 2014, we have a very, very, very broad discharge, what we call the absolute discharge rule. That means that at the end of any liquidation proceeding, Any liabilities that are still pending by the debtor are fully discharged, are extinguished, and without any requirement based on good faith or without any requirement regarding how the procedure was followed, and without establishing any kind of obligations that are left aside of the discharge. And this has been, as we will discuss further, subject to much critique by everyone. So one of the main amendments is to change the logic of the discharge and add some features regarding the good faith of the debtor. Other changes relate to the cost of the proceedings, and using technology, they accept something that has been happening this year, as I said before, is creating some platforms in order to submit documents or e-voting or selling the assets or having the audiences by means of telematic media. And finally, some rules that refer to the participation of liquidators and the mediators, mostly based in distinguishing two classes of liquidators and two classes of mediators, ones that would be subject to appointment in very complex proceedings, and the other ones that would be subject to less complex proceedings, mostly based on the idea of the simplified reorganization agreements or simplified liquidations for individuals and small business. And the last is the recognition of the interests of the employees during a reorganization agreement, because nowadays the rights of the employees are not recognized under a reorganization. They are not part of a reorganization, but also their interest is not considered in it. And the amendment expresses that the mediator, the veedor, must consider their interest and must protect their position even in a reorganization agreement. So that are the most important features of the bill. But we still have to wait what happens in the Senate.
Okay, thank you, Juan Luis. Let's move to Brazil. Francisco, please tell us about the Christmas present that President Bolsonaro gave to all insolvency practitioners and insolvency professors.
Thank you, Javier. Thank you. III for inviting me to this meeting. It's a pleasure to be here. It's a pleasure to share the panel with good friends and excellent professionals. And yes, we got this Christmas present because the law was enacted on December the 24th. So it was almost Christmas when the law was enacted, and it came into force in February. So not that much. And it's interesting because before that, we tried to enact a bill, an emergency bill, with some measures considered to be important to face the pandemic crisis, like stay and forbidding involuntary bankruptcies and forbidding some contractual clauses to be enforced, but it just never passed. And then Congress decided to use the ordinary bill of amendment of the law, the present law, Law 1101 in Brazil, that is the law that regulates insolvency. And so that law was passed in a very quick way. And in December we had a law, in February we had it working. Well, there are some interesting innovations in this law, and I would emphasize some of them. I'll start with liquidation procedure. Liquidations procedure in Brazil take a lot of time, so it was important to try to change it in order to preserve the value of debtors' assets and avoid harming creditors. So the reform made the sales of assets much more flexible and included the possibility of contracting specialized firms, service providers, or even financial institutions to help to sell any sort of assets, especially ongoing concern or as a whole, not in piecemeal. It's important to mention as well that the trustees or the insolvency professionals will have now the duty to sell the assets as a first measure. The insolvent professionals have 60 days after starting their jobs in order to provide a plan of liquidation, and they have 180 days to finish the liquidation, the sale of the assets. So instead of starting the procedure, trying to analyze the credits that are submitted to the bankruptcy, the first task of the insolvency professional here will be sell the assets, get the money enough to distribute among creditors, and then evaluate the credits and pay whoever has rights. We tried a kind of fresh start as well. We didn't have it before. We now have a kind of fresh start. It's a kind of fresh start because it's not, we don't have any guarantee that it will apply, for example, for tax debts. So, but it will apply for other debts. And it's interesting because before that it was the discharge would happen just 5 years after the end of the bankruptcy procedure, what would take a lot of time. But now it's 3 years after the decree of bankruptcy, or at the end of the bankruptcy, whatever comes first. Well, reorganization, we had some interesting innovation in reorganization as well. We have the improvement of DP financing and a sort of adoption of a version of mootness doctrine in order to provide certainty to the financiers. So if the judge allows any kind of finance for debtor, so any appeal to the tribunal would not change the situation and would not harm that borrower in any sense. We got a treatment for groups of companies that decides to file for reorganization together, and then we adopted the concept of procedural and substantive consolidation. So just being together in the procedure and to be considered as just one in order to pay the creditors of all the entities as if they were creditors of just one of them. We adopted a new thing that is the alternative creditors plan. So far in Brazil, only the debtor can file for a reorganization procedure. And the debtor still has the exclusivity to propose a reorganization plan to be voted by the creditors. Now, with the amendments, when the creditors reject the plan that was proposed by the debtor, creditors may decide in a voting, in a pool, if they want or not to propose another plan, an alternative plan, and then it's like, well, the ball passes to the other side and creditors will play. We never had here this kind of situation, and we so far had no case of alternative creditors plan. What makes sense is because it will just apply to new reorganizations, not former ones. So we are just waiting to see. Some other points that deserve some kind of attention is we now allow the sale of the whole business during reorganization to preserve concern value. And the law stimulates out-of-court alternatives. It improved what we had as an institution for out-of-court reorganization that is called recuperação extrajudicial. And there are some rules that stimulates mediation and negotiation. They are very shy. We can see so far a result, but the seed for negotiation in other areas is in the law. We, of course, confirm some technological advances like virtual meetings, electronic procedure that is very effective. We are very happy with what happened with electronic judicial procedure. It's something that happened before, and now the law was adapted for the electronic judicial procedure and written adhesion to reorganization plans. And at least one very important measure is the adoption of UNCITRAL model law on cross-border insolvency. We adopted it basically with the original writing without any important change. So this is very important. It's part of the amendment. So I think in 6 to 7 minutes, I tried to condense the most important topics of our amendments of the bankruptcy law.
Thank you, Francisco. Well, now let's move north to Mexico. Of course, Luis, it's a great panelist, a great friend, but I particularly invited him to share frustration with our own governments because the proposed bill in Mexico is doing as well as our 20 bills in Argentina. So please share frustration with us, Luis.
Yes, Javier, thank you very much for the invitation and all the panelists that are joining, Francisco, Diana, Juan Luis. Thank you to Triple International Insolvency Institute for having us here today. Yes, well, it's frustrating that in Mexico we haven't had any measure for helping the companies in distress. Since last year, the government says that there's going to be no bailouts of any kind, and they don't care about just helping the companies. They say that is not priority, that the owners of the companies has to put money from their pockets, and then they have to save the companies. They have a lot of money saved in their own, so they have to put it back. So that is the government speech. But I think that, like in any other country, we need an amendment to the insolvency law. So last year, an amendment was proposed. It's not passed, but it's proposed. The main spirit of the amendment is to have our own ley de concursos mercantiles, to use the same law, because we think that in this time of emergencies, if we put a new law, it's going to be very complicated. Remember the Italian case, they had a new law, and with the COVID problem, they decided to stay with the previous law because they didn't want to have a new law under the emergency. So it's the same case in Mexico. The amendment that is proposed is having the same law, but with emergency issues that are going to be applied, well, if the amendment is passed. So what are the main issues of the amendment? I have 11 points that are basically what is the most important issues in the amendment. First one, electronic files. Everybody's talking about it. We have in our insolvency law since 2014 the electronic files, but never use it. So we need to use it. I don't know in your countries, but right now, federal courts in Mexico are open, but no judge is going to work physically. You go to the courts and there's nobody. They are open, but you cannot talk to the judge, to the magistrates in the federal colegial district. There's nobody working. They are in their houses. So in Mexico City, we have our local courts open one day yes, one day no. So imagine a court that is opening Monday, Wednesday, Friday, and the next week, Tuesday and Thursday. So they are working 50%. It's very complicated to work like this. So one of the first things that we need to have in our insolvency procedures is that everything must be electronic. So that is one, the first one. The second one, the application form, the filing for insolvency must be pretty simple. Just a signature and under oath that you are under the premises of the law, that you are insolvent, and that's it. Right now, we have to put 3 years of papers, of financial statements, of a list of creditors, of debtors, of assets, you know, to file. I have been filing in this law 21 years. And you take maybe a month or 2 months to have all the information if the company have everything under control. Imagine right now in the middle of the crisis, they don't have, they haven't paid the accountant, they don't have the papers ready. It's very complicated. And the spirit is that you have to file and that's it. A very simple file, one paper. So number 3, automatic stay. We need it. In this moment, it is not if the judge will analyze the filing or if the file meets the standards of the law. Every file must be admitted immediately, and every application the judge has to admit and to order all the measures that are necessary for keeping the company safe and the creditor safe also. Number 4, all the frozen bank's account must be released. Right now we have a problem because when you start the proceeding, the courts cannot froze you the bank accounts. But what happened with the previously frozen accounts? It's a very complicated issue. Some judge says that they cannot unfrozen the accounts. So in this model, the companies have to use the resources and every account must be unfrozen. Number 5, there is no appeal versus the insolvency resolution. Everybody has to focus on the insolvency process and not fighting like the creditor does the insolvency resolution. There is no appeal. Number 6, we need federal courts to have a strong hand. In Mexico, it's a federal judge orders something, and if you are the creditor and you don't say, I won't listen to the judge, he's going to put you a fine, then a second fine, then it's a long process. Right now, the amendments establish that if you don't listen to the judge, you're going to be arrested, and the second time you will lose every right that you have in the procedure. Number 7, the stay includes collateral. In the insolvency procedure, you cannot execute the collateral as a creditor, the warrantors. You have to focus on having a negotiation with the debtor and not touching the collaterals. Number 8, fresh money. The judge have 5 days to authorize every new credit that the company needs, and this credit will be treated as a preference ones. Number 9, this is a good one because all the tax issues, all the tax creditors, the fiscal, the Mexican IRS is going to be treated as a regular creditor, a common one. No preference, is in the same range that all the other creditors. Number 10, if the company goes to bankrupt, all the labor executions must be held in the insolvency court, because right now we have a problem with that. And at the end, number 11, in bankruptcy, in liquidation, after you sell all the assets, when there is no more anything, no more assets to sell, and you have paid all the creditors, you have a full discharge. So those are the main issues that are pending on the Congress.
Thank you very much, Luis. Let's have a few minutes for each, the 4 of you. If you can point out which sources the legislators use and reference in drafting and enacting those amendments, sources like foreign legislations, authors' opinions, requests from lobbyists, from insolvency professionals or the courts, because as we have all here, there are common patterns in the four countries. Let's begin with you, Diana. Diana.
Thank you. Yes, about the sources, we can match some of the new amendments with a source. The first is AI, and I think the source is the reality. So I think that the AI is our new reality, is more intelligent and in more use than before the pandemic. Susskind said in his 2019 book, Online Courts and the Future of Justice, of course, before the pandemic, that we started using automation, understood as improving our traditional ways. And because of the blow of the pandemic, we are waking up to the transformation. That means it can displace and revolutionize conventional working habits and bring radical change in the professions. I think that as a lawyer that we are, we have to improve our abilities in AI. It's a request. It's not only a request for be able to litigate in these kinds of matters. It's also because that is the reality. It's closer for all us. And the second, the fast entrance, because we have right now, we have a problem before the pandemic that we file and the superintendency decides to audit all the financial statements, all the documents, and that could be take 8 months, 9 months without answer. So the new regulations say, okay, fast entrance that we think that is took of the bankruptcy code or the American bankruptcy system. And also we have automatic release of seizures. That is a little bit of the automatic state that told us Luis, and we all knew. And also the debtor in possession financing that the legislator copy from bankruptcy code and paste in our law. And third, small insolvencies. I think that the answer is the recommendation that made UNCITRAL, and even these recommendations are not ready ended or set because it's all yet a draft. We took some pieces of this recommendation, and for example, we use the same nomenclature that use UNCITRAL. You can easily prove. And for the special payment called passive sustainable, that means that you recognize that the company have like a healthy passive and non-healthy passive, and you have to pay first in your organization plan the non-healthy passive, and the healthy passive that was a way to pay in private and financial agreements. It's included right now in our decrees. But like 5 years ago, another judge was excluded from the insolvency scenarios. And the last one source, I think, are the same president of our court. First, we view the acts and then come the laws. So here, the superintendency, like a judge, like our natural insolvency judge, took part of the precedents and included in the decree. So we have a lot of different sources, and if you can see this work that present Insol about all the measures around the world to fix the crisis, we have a lot of these changes in our system right now, but it's temporary. I said to you, these rules are for only 2 years. Okay, that is our sources, Javier.
Thank you, Diana. Juan Luis, we know that the Chilean law in 2014 was modeled akin the US bankruptcy code, but we also know that you have a very strong entity, the superintendency. So what about the sources in Chile?
Okay, thank you. First, I want to say that I agree with Diana that one of the main sources is reality, mainly related to the way the proceedings must be followed. Especially during the pandemics, we have seen the importance of stressing out the need of having this e-voting and this technology included in all of our proceedings. So I think some of the amendments have been followed this path that we have initiated during 2020. But regarding the other sources, it's kind of funny because in 2014, of course, we were looking at the model laws and we were looking at the US bankruptcy code and in many features, the Colombian regulation, because we are very near with Colombia because we have the same mostly the same civil code, so the language is the same. So it's very easy to follow the track of some rules to Colombia. But for these amendments, I think it's mostly based on some critics that have been made from the judiciary, from the insolvency practitioners, and from the academy. We have seen that, for instance, the judiciary has been very critic about the extent of the discharge, the idea that a person can discharge all its obligations without any kind of requirements. They tend to express that this can lead to an abusive conduct from the debtors. So they have tried to limit the ability of the debtor to initiate an insolvency proceeding, mostly a voluntary liquidation, and to somehow limit the extent of the discharge. So that idea is reflected in the amendments. The critics from the insolvency practitioners come from the different criteria that has been applied by different courts regarding some very specific regulation, mostly related to the deep financing or post-petition financing rules, mostly related to the situation of secured creditors, that are rules that have been construed very differently by the courts. And here we have a problem in Chile because we don't have any specialized court. We have the civil courts that know of these proceedings, but also that according to our law, the rulings are not subject to appeal. Most of the rulings are not subject to appeal. So there's no review whatsoever of what they have been deciding. So it mostly depends on which is the court where your proceeding is followed, is what could happen during the course of the proceeding. So that's other thing that has been stressed as a critique. And from the academy, mostly the critics to the discharge, the critics to the construction of what a corporate debtor is, because under our system, individuals can be considered as a corporate debtor if they work independently. If they do not have a labor contract, they are considered as a corporation, and many people in Chile do not have a labor contract. So that means that many of those cases are not dealt within a bankruptcy proceeding because it's too expensive for them. Regarding the situation of the small business, of course, we have followed also the recommendations of the World Bank, of the OCDE, of especially the UNCITRAL, the recommendations that are not still ended. But I think that in this case, what the Bill of Law tries to do is to simplify only the procedural problems of this kind of small proceedings and not the substantive issues. For example, the amendment does not include any ruling related to substantial or procedural consolidation, or to stress the possibility to go through an out-of-court proceeding. So I think in this subject, we have read only part of these recommendations and not all of them.
Francisco, what about in Brazil?
Thank you, Javier. Well, in Brazil, we can find some influences from ancestral legislative guide in substantive consolidation and deep financing, for example, and model law. Of course, we've adopted model law, so ancestral was an influence. U.S. insolvency regime as well was an influence, especially when we consider the alternative plan of creditors and our version of 363 sales. That is something new in our legislation. But I shall stress out here that we've been influenced as well by Chile, especially by Juan Luis Goldberg, because I've been in a meeting with Josefina Montenegro from Superintendencia de Insolvencia y Repreendimiento some time ago, and she mentioned that they had a good reform on liquidation, and it was very effective. And many of the aspects that we talked about, and after that, Josefina provided me the contact of Juan Luis Goldberg, and some of the rules that are now improving our liquidation were inspired by the Chilean regime. We are very optimistic about that. And I would say that it's important to say that our reform was strongly influenced by the government, especially the Ministry of Economy, and they were worried about deficits, and so they were worried about defaulted taxes, and so the reform brought many rules to facilitate tax enforcement, mainly during reorganization. This is, I would say, the signature of this reform. The complete change in the way taxes are treated in reorganization and in liquidation as well, but mainly in reorganization. So, and beyond that, of course, as everybody mentioned, the reality, the experience was important, because we've been noticing some aspects that were not covered by the law, or that the law provided bad answer for them, and so it was necessary to adapt those rules or bring some other institutes to solve the problems. So I think those were the main sources of that. And of course, when I mention reality, I'm talking about insolvency professionals and trustees, and mainly courts were very active, and of course academia.
Thank you, Francisco. Luis, we know that past awful reality is a main source for the proposed amendment, but we also know that you were personally involved in the drafting of this proposed bill, so you can also tell us which sources you and the other colleagues took on account for this amendment.
Well, there is two kind of sources. The one that is pushing the amendments to be passed, and the dark side of the force that are trying to block the amendment, the banks, you know, but we will talk about those. The amendment, it was generated in the Insolvency Commission of the Barra Mexicana de Abogados. Right now, in this, we have 4 members of the Insolvency Commission: Darío Cos, Luis Manuel Mellán, Antonio Silva, and Jorge Chesal. They are listening to us right now. And we all make an effort and work because we know the problems in the practical terms. You know, I have a lot of concursos mercantiles going on during the last 21 years, and I know the main problems that we have as litigators. So everybody have a consent of which was the main issues that we needed in this emergency time. And the reality is the main one, because, for example, 2021, we have had in these 3 months, from January to March, more than 40 cases of insolvency rejected nationwide by the courts. They don't want to handle these cases. So one of the first amendment, of course, was don't ask the court, they have to admit it, and that's it, it's mandatory. But that is our main problem. And that is our main source, the practice of all the members of the Insolvency Commission and the experience. Because we are not changing the law. We are just adjusting the actual law to enforce it, right? And the other source, the bad guys, as I said, well, are the National Bank Association. They say 4 things about the amendments. 1, is going to help the big corporations, not the micro, small, and medium enterprises. Of course not. The big corporations are the ones that in the last 21 years are filed for the insolvency procedure because they have the resources, the money, and all the staff to work in a complicated procedure of this kind. The amendment tries to make things very easy, precisely for helping the micro, small, and medium enterprises. The banks say, no, we have to use the alternative dispute resolutions in insolvency cases. Yes, I agree with that, but we don't have ones, effective ones. In insolvency in Mexico, we don't have effective insolvency alternative dispute resolutions. The bank said, with the amendment, they are going to help the debtors against the creditors. Yes, yes. What do you think? That is the main purpose of it. Because the insolvency law wants to say the companies, not the creditors. They have their rights, but they have to be in a procedure that his main goal is to maintain the companies working. And they say, no, it's going to be unfair. It's going to be what it is, the insolvency procedure, like in any other part of the world. They say the insolvency procedures are against the creditors' rights. No. The insolvency are an exceptional case that we have when we have a crisis time, and then we have rules that apply in that exceptional cases. So I don't know if these banks, if they don't have any operation in other country where they deal every day with the insolvency cases. And I think they are forgetting about the FOBAPROA. You know what was the FOBAPROA in 1995 crisis in Mexico? Have a bailout for all the banks. We save all the banks 25 years ago. So why now, why they don't want to help the companies to be safe? No? Have those 2 sources, the good ones and the bad guys.
Thank you, Luis. As we are running out of time, I would like to comprise in just one the following 2 questions for you. First, if you can make your own assessment or give us your own opinion regarding the amendments passed or proposed, and which topics, which tools would you include that they are not already proposed or amended in your own laws. Diana?
Thank you again. I know with time, but I want to tell you something. I think our legislator, with the important support of the Superintendency of Corporation, put our system in a higher level. But sometimes you can see some rush or some I don't understand. And they have brought some institution for other places that don't fit with our size, economy, our way of thinking. So I think that we have to be conscious that we are a country for the third world, and we are in South America. And for example, we only have right now 3.6 people vaccinated. So, and we are 48 people. So that is a consideration. And if I can imagine something that we don't have, I think three things for do it very quickly. First, that is not like a rule, but I have to understanding why we need an understanding change, because we have to live to think that the debtor is always unfaithful, untrusted, because this idea doesn't help to the companies. Like we said, the creditors have right, but the debtors also. So we have to find some balance within that. And we need a really pre-insolvency system, like in Spain, because we need that the debtor can negotiate with the creditors without the possibility of being sued or to be threatened with seizure. So, and at the end, and that is a request that we have been doing the last, I don't know, 10, 15 years, that we need a judge, a career judge. The next year we have elections and the president will change. So we will change the superintendency and also the judge of insolvency, and every single judge, even are there good professionals, I think that they always change the precedents, and you don't have security about what will happen in a case. So that I think that I want to introduce to our system these two things. Okay.
Okay, thank you. Juan Luis?
Yes, I think that from the Chilean point of view, the current regulation has been working very well in most of these features. I think the amendment tries to fix some of the problems that have been experienced, mainly related to small business and to individuals. But at least from the point of view of the corporate restructuring, the idea of the automatic state, the deep financing has been working well. But not for very large companies such as LATAM that have to go to the US to file a Chapter 11 and then go through the cross-border regulation in Chile, because of course our system is not prepared for such a large company to go into an insolvency proceeding. So at least now we have a solution that's having the cross-border regulations set in our country. There are some specifics that, of course, must be reviewed. I think the most troublesome has been the rules of the discharge, the extent of the discharge. But also, I believe that there has been some problems, but somehow a consensual problem, because we have created these specific proceedings for individuals. Now we're proposing specific proceedings for small businesses, but mostly based on the idea of simplifying the proceeding itself, but not looking at the special characteristics of the debtor. For instance, just to put an example, nowadays we have a problem because we have such a large discharge or absolute discharge rule that alimonies can be discharged. So you say, like, this doesn't make any sense, that there's a father or a mother that owe money for the children's support, and according to a rule, that liability could be discharged. So the courts have tried to limit the extent by means of using international criteria of best interest of the child and everything, but it's not said directly in the rule, because the rule, the insolvency regulation only focuses on the fact of the simplification of the proceeding itself. And with regard to small companies, we can see, from my point of view, the very same thing. We have tried, or we are trying to simplify the proceeding, but we are not considering the fact that in most of the small businesses, the liabilities and the assets of the business and the personal liabilities are somehow intermingled. There's no review of the position of the employees in these small businesses that's very different to large corporations. And there's no coordination whatsoever with the special schemes that we have set in Chile to admit or to enhance the possibility of the small business to access to credit, mostly the public guarantee schemes, that's called the FOGAPE, and how these kind of credits are considered within the insolvency regulation. So I think there are very big gaps over there that should be filled or should be discussed. And finally, I want to stress the idea of having, of course, an expert judiciary. As Diana was saying, they have a problem, I understand, like a political problem of the appointment of the natural judge. We have the somehow different problem because, as I said before, most of the judges that are dealing with insolvency proceedings, not in Santiago, but the capital, but in other cities, is the same judge that in the morning is dealing with domestic violence, in the afternoon with, I don't know, a criminal proceeding, a labor proceeding, and somehow a reorganization proceeding of a company. So it's very, very difficult to follow a path to understand how these courts are dealing with somehow very complex insolvency rules or other rules that must be somehow adapted in an insolvency scenario. So I think, or I agree that if we have a good substantial law, we also must have good people to apply, prepare people to apply them. And I think that judges make their best efforts, but it's very, very complex for them.
Thank you, Juan Luis. Francisco, your views?
Okay, well, some points that I would like to stress out here, and I see Judge Stone and Judge O'Reilly mentioning that electronic procedures work in Argentina and United States, and I would say in Brazil as well. It works pretty well, and it's important for us. I do believe that electronic procedures will help to impact in the effectiveness of insolvency procedures, because insolvency procedures are basically procedures. So it's important, the procedure part of it, it's important that it works quite well. And there's another dilemma here. It's been discussed everywhere during the discussion about the amendment. And we're talking about the crisis as well. Of course, companies must be safe. Debtors must be protected. That's it. It's important. But at the same time, debtors, entrepreneurs will need new money, will need credit. So when you see right now that people prefer to invest their money in cryptocurrencies that are completely nothing related to economy, is out of the economy, and they consider it safer than, for example, investing money in some businesses that are now quite cheap because we are in a crisis. Something seems to be quite wrong. So it's quite difficult for a country and for policymakers to define the right balance between protecting creditors, and I think that is the mystery, protecting creditors, especially protecting the company's ongoing concern, and provide to creditors a kind of protection that will not stimulate them to look for other sorts of investments. We are living in a crisis right now, and liquidity is very important. So money now, it's important for the companies. At the same time, at least in Brazil, we see lots of people that just don't know what to do with their money, as the interest rates are very low right now, and they really don't consider to risky their money in an enterprise. So I think this is the great challenge right now. Well, what is missing in our reform? One of the points that I think it's missing is it was a reform of the main law, and the main law has been proven not to be effective for small and micro enterprise. It's too expensive, too bureaucratic, it's too complex for a solution for small businesses. So there's another bill that has been approved in Senate. It's now with the congressman, and we hope that we get this bill approved and the law enacted, because probably micro and small enterprise will be the larger group of victims of the pandemic. Right here in Brazil, we have lots of restaurants and small markets and service providers closed or without a real expectation to return to market. And the other point is we have here a restriction on who can use reorganization procedure to solve its problems related to insolvency. We adopt a very straight concept of enterprise, and enterprise leaves a lot of entities that are economic agents out of the possibility of using reorganization for them. And I'll give you some examples. Now in Brazil, we had a petition for reorganization that's been accepted, that was filed by a football club. That is definitely not an enterprise, but it's an economic agent. There is an important cash flow in a club. There are lots of employees, and well, it's an important institution, but they were not included in those who could file for reorganization. Some associations, there are hospitals or schools and universities, for example. They were not enterprises as well. So the first proposal for the reorganization procedure amendment was to make broader that aspect and allow any economic agent to file for reorganization, as reorganization is a way to keep ongoing concern value, to preserve value, so there would be no reason to restrict it. But especially by the government decision, this has not been made, and now it has been made. It's being made by the courts. The courts are, in fact, broadening the possibility of reorganization, which is not good, because they are just considering these institutions as enterprises, and that would bring other consequences beyond insolvency. So I think those are very important issues, and I think the main challenge for legislators and for governments and for academia and for professional is to find an equilibrium, a balance between how to treat creditors and how to save debtors without harming too much one or other, in order to provide during the crisis a good environment for economic activity.
Thank you, Francisco. Luis?
Well, I think we need 4 main issues in Mexico to work better in this matter of the insolvency cases. First one, the specialized courts. Since 2014, we have in our legislation that we are going to have federal courts specialized in insolvency and in all the commercial matters. But in reality, we only have a few judges along the country that are specialized in these matters. In the main cities, Mexico City, Guadalajara, Monterrey, we don't have any judge specialized. So it's very important, because the other judges, the other federal judges, are rejecting all the cases of insolvency right now. Second, we need a pre-insolvency tools. They are very necessary for the small business. they can have a lot of impact in this moment, but we don't have any effective pre-insolvency tools. So I think we need to work in the alternative dispute resolutions in insolvency. Number 3, we need an insolvency for the natural person. We don't have it in Mexico. We don't have an insolvency that works for everybody that is not merchant, that is not a company. Right now, there is an amendment proposed in the Congress a few months ago about this, but it's necessary that we regulate the insolvency of the natural person. Right now, a lot of people cannot afford to pay the mortgage, credit cards. They have a lot of unpaid credits, and they don't have any procedure to go and to relieve themselves about it. And most important for the economy, number 4, we need a regulation for the micro, small, and medium enterprise. So I think it's very complicated in Mexico to change the Ley de Concursos Mercantiles because it will be a lot of work. So what I thought is that if you make an amendment to the actual legislation, Ley de Concursos, and establishes an amount like in the United States, $7 million, or if we put a measure of what we are going to consider a micro, small, and medium enterprise, and we change the rules for them. And I propose basically 5 changes. One is automatic stay when filing. Second is reduce to the absolute minimum all the paperwork that you have to show to the court, financial statements, a lot of paperwork that you have to show right now. 3, reduce the cost of the insolvency practitioner because sometimes it's very expensive. Maybe the court should pay those. And eliminate restrictions because the banks, if you are in an insolvency procedure, cannot lend you money. Well, they can, but they have to reserve 100% of the lend. So which bank is going to give you money if it's going to cost to the bank the 100% more? It's not competitive. Nobody wants to do it. It's not a business. So we need to eliminate those restrictions to the banks in order to have fresh money in our companies. That is my conclusion.
Thank you very much, Luis. Well, we have a few ideas or questions in the chat. I will condense the reflections coming from the bench, in this case, Judge Stone from New York, Judge O'Reilly from Buenos Aires, and Judge Adler from California. These 3 prestigious judges are telling us what it is and it should be that all the courts has just now moved on a virtual proceeding. And this should not be just for the time being, just for the pandemic. It should be here to stay. And furthermore, and following what Diana told us about the example in Colombia and what it happens in the US courts, the filing not only should be electronic, but also with forms, like Luis told us that it is a proposal in Mexico. It should be easy for all the debtors to file, again, not just electronically, but with simple forms that, for example, are those that are online in the US court's website. The other comment or question coming from Alejandra Guardiola, that in a certain manner has been touched by all the panelists, has to do with special proceedings for micro, small, and medium businesses. In bankruptcy, one size does not fit all. Most of our insolvency proceedings are focused on big companies. And the example is that even the US system, that is considered one of the most efficient systems, insolvency systems, in 2019 passed the Small Business Reorganization Act, and Francisco told that he thinks that this should be a topic to be addressed in future amendments. Juan Luis said the very same thing in Chile. Luis in Mexico, and Diana told us that they have already included a new procedure just for micro and small businesses. And to be really clear, the real motor of our regional economies are the micro, small, and medium businesses. They provide most of the employees. They pay taxes, so we need special proceedings for all of them. Let me check. There are new Luis, there's a question in Spanish for you regarding the individual's insolvency regime that is proposed in Mexico.
Okay, I see there are two questions. One related to this is a new proposal. Is a proposal by a senator from Movimiento Ciudadano, there is a political party here in Mexico, and it's talking about the insolvency and restructuring and financial restructuring of the natural person. It's just been presented. Right now we have a procedure in the Código Civil, the civil code, for the natural person, because they are not merchants. So the procedure is not federal, it's local, but it's not working because you don't have automatic stay, you don't have any tools for restructuring, have discharge, you know. So what is being proposed is to have a civil code amendment or a new legislation about the insolvency procedure for a natural person. In this case, they're proposing a new law, a federal one, to have every people that has commercial relationships, all the consumidores, you know, all the people that are consuming in the market, to be allowed to have a restructuring and to have a discharge, to go back to the market, because in the United States they do that. You cannot have any more credit. Well, restructure yourself. Let's see what happened. But the system needs you back. Needs you to start buying again, to start spending again. No. So what we need also in Mexico? We need that these people that doesn't have any more credit cards or any more credit anywhere, that are using the credit cards of their brothers, their cousins, or some friends, because they lend the credit cards to them, that they go to this procedure, that they are very effective, fast mediation procedure, and they go back to the market, to the consuming market. And in the second question about the federal courts, yes, the main problem is that right now our federal judges have two procedures in their hands: the amparo and then the concursos mercantiles. So the amparo is a very easy proceeding 3 months, more or less, you have only one party that is complaining about the authority, one audience, and the resolution. And the insolvency proceeding you may have 10,000 creditors, maybe 3-4 years of procedures, and they don't like it. So if you have a specialized court that only is going to see commercial bankruptcies, they won't reject the petitions because they will be out of work. That's what they do only and only. So that's why we need it to be, they are already in the legislation. Now we need the judicial authorities to name these judges, to appoint these judges, and to start working right now.
Thank you, Luis. Elizabeth, I don't know if you are able to allow yourself to speak, but we would love to hear your experience as a U.S. judge applying the brand new subchapter 5 of Chapter 11.
Okay.
Hello, my friends.
Hello, Elizabeth. How are you?
I am good. Buenos días de Nueva York. Estoy aquí en Brooklyn. Con mucho trabajo en el corte. You went in and out a bit after I heard my name, and if you're able to unmute. So other than my warmest greetings, how may I be of assistance to this wonderful group? It is so good to see you, by the way.
Please tell us about the subchapter 15. Subchapter 5, sorry.
No, I knew what you meant. It is my pleasure. We had amended into our bankruptcy code shortly before the pandemic a new SME-focused simplified Chapter 11 called Subchapter 5. And then the pandemic came, and the threshold of eligibility, which is so important, was increased so that companies with debt of up to $7.5 million rather than 2.7, I think, 7.5 were eligible for this new streamlined type of Chapter 11 reorganization. Of course, debtor in possession, but with some significant changes, including that in Subchapter 5, there is a trustee appointed, but it's a different kind of trustee. It's kind of like a coach, a person whose job is to work in the direction of a consensual plan with all of the stakeholders. And it's been very successful. The company has a few more tools in the toolkit, including the ability to repay a small amount of legal fee debt, which facilitates keeping the small business's lawyer that knows its business in place. Some of the strict rules about priority are modified so that the owners, if they are successful in all the other respects of the reorganization requirements, are able to retain an ownership interest, even if they do not necessarily pay 100% of everything to all of the other creditors. This preserving an interest for equity would be a significant change. The cases move quickly. We have our first scheduling and management conferences very early in the process so that people focus and the court focuses and the trustee focuses, the coach in effect focuses on the process. There are no United States trustee fees, and that's not the biggest deal, but you know, in a reorganization of an SME, every little piece can help. And it's worked. Lawyers have filed these cases. They have confirmed. They've met the goals, I think, of the amendment. And I remember from speaking at the TMA Brazil conference, I can remember being at the Renaissance Hotel and hearing from some of the Brazilian lawyers that there were some similarities to our then upcoming new subchapter 5 and aspects, I believe, of the Brazilian law. I think it could be a very interesting conversation to compare our system's efforts to meet the critical needs of the SMEs in the current environment. It's a long answer. I'm sorry to go on so long, but it's one of my favorite topics. It's very important.
We totally agree. All our insolvency regimes should focus better in micro, small, and medium businesses. The big companies has good lawyers, good accountant, good financial counsel. The other one needs more protection from the law. Well, if nothing else, I will close. I really would like to thank the 4 presentations. All of them were brilliant. Thank you very, very much for your participation. And again, thank you very much for all the attendees that keep all along with us hearing. And of course, thank you for those that make questions or comments on the chat. Thank you very, very much. Have a nice morning or afternoon wherever you are.
Thank you.
Thank you very much.
Thank you very much again.